Yes, Mr. Devereux.
May it please your lordships, may it please your ladyship. I'm grateful for the court giving me some time due to unexpected matters that arose during the course of the morning. As the court is aware, shortly before coming into court, Mr. Battersbee fell ill, and it was obvious to all of those who were surrounding him that he was ill, yes. Very ill. An ambulance was called, paramedics attended, and as the court knows, there's a suspicion that he suffered a heart attack or a stroke. He's been taken to hospital for further diagnosis, treatment, and care.
Really a very, very unfortunate turn of events, but matters seem to move very quickly, and he's in good hands.
Yes.
Now, so
yes.
That at least is a comfort.
In addition, my lords and my lady, last night I was alerted to a matter that I hadn't been alerted to previously, relating to the mother's assertion that she had seen Archie attempt to take breaths on Friday and on Saturday, or Sunday, I need to check but on at least 2 occasions. In the light of that information that came to me very late last night, I indicated as a matter of professional duty that that information needed to be before the court. It needed to be before the court in a formal manner, that's to say by way of a witness statement, and that witness statement has been provided to the court from the mother, and I know that the court has considered that.
No, I was handed a witness statement reportedly from the mother.
Yes.
And a witness statement from one of the doctors, and I simply looked at the front pages, or the front page of each,
yes,
to understand what it was, and
yes.
I deliberately haven't read it.
Yes.
And neither my lady nor my lord have seen it.
Well,
to see it in my hands.
Forgive me, that information didn't reach me. All I knew was that the statement had gone back, but I didn't know the status of the statement, so forgive me if I'm being brought up to speed now. The statements and the response from the trust deal with the issue of the mother's assertion that, supported by footage, that Archie was attempting to breathe in some way or another over the course of 2 occasions in the last couple of days. And it is my application that material is before the court, both the material plainly from the mother, but also I accept and acknowledge the material from the trust. I've, and this is absolutely no criticism at all, but in the last few minutes been provided with 40 pages of medical notes that I assume cover this period of time.
Well, let's plainly, if that matters to be investigated, but we need time to read the statements, you need time to look at any material. But what is the basis of the application at this stage of a permission to appeal application for this court to see fresh evidence? Well,
this court canvassed with me last week whether this court, if, and I don't know the outcome, but if I were to be successful, whether this court would be in a position and should undertake an evaluation as to best interests. And I sought to persuade the court that it was not in a position and should not undertake that assessment for the reasons that we canvassed, particularly on Friday. The further evidence is evidence that arises since Friday. It's evidence that throws up, but that hasn't been subject to analysis, proper analysis by, for example, an independent expert on this issue, and in those circumstances, I suggest it's evidence, if it's permitted to be admitted, which I suggest it should be, because this court is going down that road of evaluating or considering to evaluate best interests, then it's evidence that would...
So it becomes relevant if the appeal is successful.
Yes.
And there's then two routes open up.
Yes.
One is for this court to undertake the best interest evaluation itself, or remit it to another judge.
Yes.
For that course to be undertaken. So the statements that have been given to me this morning are relevant to that exercise.
Yes. If, of course, I don't succeed, then they don't become relevant to this court. They may be relevant in any further application made to the High Court on the basis of a relevant change of circumstances.
Right. Thank you.
But that's then our position in very broad terms on the very recent evidence. In relation to the judgment that this court anticipated giving at 11:30, our application is to adjourn that, to allow the father to be here and to provide instructions to his legal team. And those are two critical points in support of the application to adjourn. I, of course, don't know what the position will be over the next hours or day or days. So I'm simply forced to make that application. I was not able...
None of us know, and I'm just really feeling my way to try and understand what the timescale is, and so no one should read into what I'm about to say that I've got a view, because I haven't.
No.
But it's likely, after an event such as this, that further tests will be done. But doctors are cautious. It is likely that the advice will be to rest for at least a period.
Yes.
And not to be re-engaged in, certainly, an event such as this morning, which would have been stressful for all the people involved, and plainly may have had an impact on Mr Battersbee. So I think we're not talking about him being necessarily available this afternoon or tomorrow. Or
we're not.
Something of an immediate period.
And 2 points flow from that. For clarity's sake, I've taken instructions from the mother, and she was very clear that she wanted me to make the application to adjourn. I obviously was not able to take instructions from the father.
Well, I
may be able to...
Unless any information to the contrary came, I would assume that he, like the mother, would wish there to be an adjournment.
Yes.
It doesn't surprise me that is the application you make in these circumstances. Right. Part of necessarily any consideration has to be the interests of Archie.
Yes.
And it is plain that the court has moved extremely swiftly to bring this case to this stage.
Yes.
Not really more than a working week after the judge had given his judgment, on the basis that any delay is likely to be contrary to the best interests of Archie, one way or the other. And so that's part of the equation. This isn't an ordinary case.
No.
This might be the way in civil litigation or some other matter where an adjournment, whilst regrettable, would not be remarkable. That's probably all you can say, because you haven't got any more information than you have transmitted.
Can I just turn my back
Yes.
on the court and just check that there's nothing
Yes.
else that my team want me to
Yes.
provide to the court? One further point, it probably dovetails with some of the other points, and it's in the context of these being unusual circumstances that have happened very rapidly, and I'm feeling my way forward too. Those behind me make the good point that, in my submission, that if the court were to give their judgment now, then it would obviously have to be transmitted in some way or another to Mr Battersbee, and we don't know what his position is, and that could lead to all sorts of consequences, further consequences. And thinking about it from Archie's point of view, he would undoubtedly want his father to be safe and stabilised before any decision of this magnitude is provided to him. I think that's all I can say.
No, thank you. Thank you, Mr. Miller and Ms. Watson. Is there anything you wish to say about the application to adjourn? I think we take matters in stages.
Only possibly the obvious. Mr Justice Hayden clearly considered, taking into account the best interest of Archie and wider considerations, that a degree of expedition was required for the orders he made. This court seems to have been of the same view in terms of listing these proceedings, and we respectfully agree with the approach adopted both below and in this court in the difficult circumstances that everybody finds themselves in, but most importantly Archie. And that clearly goes into the balance in relation to any application to adjourn, which is a matter for the court, but I don't think I can say more about that, except that's in the balance, in that consideration. And there are obviously human and personal considerations.
Yes.
The only other thing is obviously we don't know what the judgment would be, so we can't really hypothesise where it would go after that at this point if the substantive evidence was looked at. I think all we can say, and again it is stating the obvious, is that the consistent evidence of the clinicians throughout these proceedings, and indeed throughout Archie's time in the hospital, has been and continues to be that there have never been any additional ventilator breaths witnessed by any
We're not dealing with that point at the moment. So I'm just taking it in stages, and this is the application to adjourn because of what's happened with Mr Battersbee this morning. Thank you. Yes, Ms Watson.
My Lord, taking that very briefly, whilst there are obviously personal and social matters to be taken into account, the Guardian's focus is on Archie's best interests, and regrettably, notwithstanding the difficulties that the court faces today, and notwithstanding, of course, the concern that we all have for Mr Battersbee, it is the Guardian's position that any further delay would not be consistent with Archie's best interests.
Thank you. Mr Devereux, can I ask whether what seems to have happened to Mr Battersbee this morning comes out of a clear blue sky, or whether he's a gentleman who has had a medical history of heart difficulties?
Previously, I'm instructed, had a heart attack. Was it last year? Was it last year? So he has previously had a heart attack last year.
Yes. Thank you. Well, we'll rise for a short
Thank you.
time.
All right.
Mr Devereux, we are extremely sympathetic to Mr. Battersby's situation, but we are driven by the view we've had throughout and maintain, which is that a decision in relation to these matters is urgent when looked at from the point of view of Archie's best interests, which should be our guiding principle. We are concerned that it's unknown at the moment what time and what day Mr. Battersbee might be in a fit state to come back here. This is plainly a stressful environment, and it may well be some time before he would be advised to put himself back into it. And so it's certainly not a short time, and it's unknown. The question of how the decision today is communicated to him depends partly what the decision is, but that's a matter for those charged with his care to determine. There are various options, and certainly the printed version of the judgment today will be available to be circulated to the parties sometime later today. And I think that the live stream is also available going forward on, not iPlayer, but on the court's YouTube channel for him to watch in more comfortable surroundings. But these are matters for those who have the care of him and don't elevate themselves as to a factor indicating that we should adjourn until he's in some more stable condition to receive the news, whatever it is, of what the judgment is. So I'm afraid the application to adjourn is refused. We will then therefore move to give our judgments, but in terms so that those who are keenly interested in this don't have to sit through what may be an hour of oral judgment. We propose to announce our decision now and then rise for a short time to allow you and others to take stock of whether or not any or all of those who are in court at the moment wish to then come back to hear the reasons that we'll give in the judgment that will then follow. And again, so that people can manage their time. It's now 12:25, but unless there's a reason to do so, we will propose to carry on with that process through the luncheon adjournment rather than rise and then all come back at 2 o'clock or whatever the time might be. So that's the course we will follow. And so the next stage is to announce our decision, which is that after careful thought, we refuse permission to appeal on all of the grounds, including the ground that was advanced orally at the hearing. The result, therefore, is that the application for an appeal is dismissed, and the orders made by Mr Justice Hayden as to Archie's best interests and the declaration made will stand. So we'll rise now for 10 minutes, unless some further time is required.
Thank you.